Have you recently lost a loved one and now you're being told that you're going to have to go through probate? The very next question that you're probably asking yourself is, how much is this going to cost? And maybe even more importantly, who actually pays for probate in Florida and when does that money come out? In this video, I'm going to explain what probate in Florida typically costs, what factors make it more or less expensive, and a few ways families sometimes are able to reduce costs or even avoid probate altogether, so that you can make an informed decision during this emotional time. And before we go any further, let me just say that if you're watching this video because someone close to you has passed away, I'm truly sorry for your loss. I work with families going through probate all the time, and I understand that this process often starts when emotions are high, energy is low, and answers feel hard to come by. So let's slow things down a bit and talk about the probate costs in plain English. For a comprehensive list of everything you need to know about probate, click the link in the description. In Florida, probate does not have one single flat cost. Instead, it's made up of several different expenses, and the biggest factor that affects the total cost is the value of the assets that must go through probate, and not necessarily the total value of everything that the person owned, and that distinction matters. The largest expense in most Florida probate cases is the probate attorney fee, and Florida law provides guidelines, not fixed prices, for what is considered reasonable compensation for going through probate. Many attorneys follow these guidelines while others offer a flat fee depending on how complex the estate is. For smaller estates, often those that qualify for summary administration, attorney fees may just be a few $1,000s. For larger estates, that may require formal administration. Attorneys' fees are commonly based on a percentage of the probate estate. In a general estimate, many families feel legal fees fall somewhere between 2 to 5% of the probate assets. So for example, on a $500,000 probate estate, attorney fees alone could reasonably range from $10,000 to $25,000 or more depending on the situation. Next, there's a personal representative, also known as the executor of the estate. Florida law allows the personal representative to be compensated as well, using similar percentage structure. Although in real life, many times family members choose to waive this fee, especially when they're the personal representative. They may be a spouse or adult child. But if a professional personal representative is involved, or if the family dynamics are complicated, this is a cost that should be planned for. Then there are court administrative costs, including filing fees, required notices to creditors, publication costs, certified copies, and other administrative expenses. And while these costs are typically smaller, they are avoidable and usually range from a few $100s to a couple $1,000s. Some states also have additional costs such as real estate appraisals, accounting or tax preparation, property insurance, maintenance or repairs, especially when a home is involved. Not every estate has these expenses, but they do come up often enough that it's important to be aware of them early on. And one of the most common questions that I get is, do heirs have to pay all of this out of pocket? In most cases, the answer is no, because probate costs are typically paid from the estate itself, not directly by the heirs. And when a home is part of the estate, many families choose to sell the property during the probate process. So those expenses can be covered before the proceeds are actually distributed. This is often where I come in, not just to sell a house, but to also help families understand the timing and options and expectations as they go through the probate process. Now here's an important question. Can probate costs be reduced or avoided altogether? Sometimes the answer is yes, because certain estates qualify for summary administration, which is faster and less expensive. Assets that were properly set up in trusts, joint ownership, or with beneficiary designations may bypass probate completely. Unfortunately, many families don't learn of this until after the loss. But understanding your options now can still make a meaningful difference. If you're dealing with probate right now, here's what I want you to know. You're not alone. This process can be navigated, and with the right guidance, it does not have to feel overwhelming. If you have a home involved and you're unsure whether to sell or when to sell or how probate affects the process, I'm always happy to have a no pressure conversation, no cost or obligation at all, to help you understand your next steps. My goal is simple: to provide clarity, reduce stress, and help families move forward with confidence. If you have questions and you'd like a free, no obligation consultation, you can reach out to me at 904-544-5252.